So let's start. Welcome to lecture number 9. I think I don't have to remind you that this lecture number 9, which means that you have 10, 11, 12, 13, 14, some weeks until the final exam, so maybe you should start preparing for them, etc. So let's start with the short revision of what we did last week. As you might remember, today's lecture is connected to last week's lecture. So last week I told you that last week's lecture is connected to today's lecture. What does that mean? It means that today we will use what we were talking about last week. For example, we were talking about the non-necessity of documents in Japan. We were saying that in Japan, we don't need to have a document in order to have a contract. We were saying that we can have a contract also orally, as long as we have an offer and an acceptance. And we said that yes, but there are some exceptions where we need documents. For example, we will see some exceptions today. Consumer protection. This is today's topic. Last week we talked about fraud and duress, sagi, and kyohaku. We said that, okay, so who would like to read Article 96? Yes, please. Could I have your name? No. Either you have many sisters who look like you and you're changing or something, but you look different every week.
Yeah, I guess.
No, you don't have to answer that. Okay, thank you. So, Chloe, here's the microphone.
Article 96. Manifestation of intention which is induced by any fraud or duress may be rescinded. In cases any third party commits any fraud inducing any person to make a manifestation of intention to the other party, such manifestation of intention may be rescinded only if the other party knew such fact. The rescission of the manifestation of intention induced by the fraud pursuant to the provision of the preceding two paragraphs may not be asserted against a third party without knowledge.
Thank you very much. So, Chloe, as you remember, we were saying last week that the civil code, the Japanese civil code, was created in 1890s, and at that time the legislator did not care about whether ordinary people understand its content. He only cared about the fact that lawyers and judges could understand the content. And if you are a lawyer or a judge, you know what fraud is. You know what duress is. So that's why in Article 96, there is no definition. So I gave you the definitions last week, and I talked to you about some issues. Issue regarding fraud. It's not written in the provision that Chloe just read, but we were saying that in order to have fraud, we need to have double intention, which means intention to deceive plus intention to induce a manifestation of intention. That means intention, for example, to tell a lie, plus intention to make the other buy something. Okay? Double intention. And we were saying that it is very difficult to prove the intention to deceive. The person who asks for the rescission, so the person who asks for his or her money back, has to prove that the other person had the intention to deceive, which is really difficult because if the other person tells to the judge, I thought that this cream actually works. I didn't know it's not working, has no effects. Or, even worse, if he was persuaded by his employer that that cream, that product is effective, has effect, then actually he had no intention to deceive. He was thinking that he is telling the truth. Second, duress. In this case, as you remember, I mentioned to you about the Japanese practice, especially many years ago, where people would come to your house and they would tell you, you know, I left prison yesterday. I have no money, I'm making a new start. That's why I'm selling you this, which is worthless, but you need to buy it for 10,000 yen for me. And of course, it would be difficult for you to say no because you know that he has just left prison. And if you're alone, then it's really hard to say no. But you can rescind and take your money back. But of course, you need to be able to find him or her, etc. That's another issue. However, so-called bad people, the so-called mafia, is really clever. They know legislation, they know law better than us. So they know that if you indicate malice to another person, if you tell him, I'm gonna hit you, or something bad is going to happen to you, it's gonna be duress. They don't do that anymore. You will see what they do today. They don't do that anymore. So the court will be like, yes, but he didn't tell you that he's going to hit you or etc. if you don't buy the product. And you would say, yes, but I was afraid. Yes, but he didn't, so it's not duress. Finally, we were talking about the regulation of content of contracts, and we were saying that we mainly have two weapons: public policy and good faith. The issue with public policy is that it needs to be something really heavy. A contract to kill somebody. Wasn't there a movie, A Contract to Kill? No, it was A License to Kill, sorry, yes. Was that James Bond? Thank you. Okay, so here it's not license, it's contract to kill, anyway. For example, or a contract to sell drugs, etc. And we also have good faith, which is the last weapon. So, do you have any questions regarding last week's? Yes, Matthew. Could you, Chloe, please pass the microphone to Matthew?
Just a little question with regards to fraud. Is it possible in Japan to argue kabe et emto principle?
Okay, it is, but it doesn't have to do with this article.
Just the concept of buyer beware, the buyer is the responsibility of the buyer
Yes,
to check.
exactly. So it has to do with the sale contract. So you would use articles 555, etc.
So it cannot use as a defense in fraud cases?
Yes, not here. Yes,
Okay,
exactly.
thank you.
Okay. Any other questions? So, let's move to today's lecture, consumer contracts. So, we saw that if we use the general ordinary contract law, there are some issues. But today we have the so-called consumer law, which is more protective for us consumers. So today's lecture is even more interesting for you because you will learn some weapons which you can use if you live in Japan. Now, the issue is that we don't have a comprehensive general law about consumer law or consumer contracts. What does that mean? If you go to France, they have the so-called Code de la Consommation, Code of Consumption Code. In Italy, they also have that. In Luxembourg, they also have that. So they have one law in which you can find almost everything about consumers, which is really helpful. as a consumer, you just open that code and you can find almost all your rights, etc. In Japan, we don't have that. So, please be careful. There is no comprehensive law about consumers. Second, we have many special acts regarding consumer protection, which means that, as you can easily understand, it is really difficult for ordinary people to find what is where. So, it's good for you as lawyers in Japan in the future, if you want to become lawyers, because you can earn money from consumers by helping them in consumer issues, for example. So we have the Consumer Contract Act, CCA, Shouhisha Keiyaku Hou, which has to do with consumer contracts. We have the Act on Specified Commercial Transactions, Tokutei Shou Torihiki Hou, which has to do with specific transaction types, and we have many, many other laws on consumer protection. So, many university professors are saying, hey you, Ministry of Justice, shouldn't you maybe create a common consumer law, consumer code maybe? But the answer is yet no. Why is that? Because in Japan, the ministries in charge of each act are sometimes different. And no ministry wants to lose an act because it loses competencies. So, these acts do not all belong to the Ministry of Justice. And this is a very large issue you will face in the future if you live in Japan. Each act belongs to the competence of a different ministry, so this makes things complicated. Okay, now, who would like to read Article 1 of the Consumer Contract Act? Okay, yes please. As always, Chisaki. Well, not always, almost always.
Article 1. The purpose of this act is to protect the interest of consumers and thereby contribute to the stabilization and improvement of the general welfare and lives of the citizens and to the sound development of the national economy in consideration of the disparity in the quality and quantity of information and negotiating power between consumers and business operators by permitting a consumer to rescind the manifestation of his or her intention to offer or accept a contract when the consumer has misunderstood or was distressed by certain acts of business operators, and by nullifying any clauses in whole or in part that exempt business operators from liability for damages or that otherwise unfairly harm the interests of consumers, in addition to providing a qualified consumer organization with the right to demand an injunction against a business operator, etc., for the purpose of preventing the occurrence of or the spreading of damage to other consumers.
Thank you, that's excellent. So, Chisaki, if a friend of yours asks you, what's this Consumer Contract Act? You just read Article 1, if you have enough time to do it. So, the important part from Article 1 of this Act is the part which says disparity in the quality and quantity of information and negotiating power between consumers and business operators. Why is this important? Because the civil code is based on the idea that the parties are equal. So the civil code is based on the idea that I and a large company are equal, which is not most probably the case because they have a lot more information and their negotiating power is stronger. So this was the first act in Japan which admitted this fact. It was the first act in Japan which said that no, consumers and business operators, 消費者 and 事業者 are not equal. There is a disparity in information and negotiating power. So, that's why they made it easier for us, consumers, to be protected compared to the provisions of the Civil Code. What's a consumer contract? This is the only act which in Japan, which includes a definition of consumer contracts. Consumer contracts are contracts between consumers and business operators. What's a consumer? Consumer is an individual not acting for business purposes. What's a business operator? 事業者, a corporation, association, or individuals acting for business purposes. Let's see that in the provision. Who would like to read these 3 paragraphs which say the same thing? Thank you, Saki. As always, not always, as usual. Article 2, paragraphs 1, 2, and 3. They're quite short.
The term consumer as used in this act means an individual. However, the same shall not apply in cases where said individual becomes a party to a contract as a business enterprise or for the purposes of a business enterprise. 2. The term business operator as used in this act, excluding Article 43, Paragraph 2, Item 2, means a corporation or association or an individual who becomes a party to a contract as a business enterprise or for the purpose of a business enterprise. 3. The term consumer contract as used in this act means a contract concluded between a consumer and a business operator.
Thank you. So, please be careful. These provisions apply only to this act. But there is no other act which gives us a definition of consumer contracts, of consumers, and of business operators. So we can use this in general maybe to explain what a consumer is, what a business operator is, etc. You need to be careful. Why? If you and a housing company conclude a contract regarding a lease of an apartment, you can use this. You are consumers, and the housing company is a business operator, so you are better protected compared to the case where you and another individual conclude a lease contract of an apartment. So please be careful. You can use these, so the context that I'm going to explain to you about today, only if it's a consumer contract. So not in cases of contracts between individuals. So let's see what is different from other cases. We were talking about documents last week, and as I also told you today, we were saying that in Japan, we don't need documents. Contracts can also be concluded orally. Of course, you need to prove that if you're going to ask for that contract to be performed. But if you can prove it, then you don't need to have documents. In the Act on Specified Commercial Transactions, in Japanese, Tokutei Shou Torihiki Hou, the business operator must give you a document about the contract. If it is a door-to-door sales, 訪問販売, telemarketing sales, 電話勧誘販売, door-to-door purchases, 訪問購入, etc. Why? Oh, who would like to answer this question? So, in Japan, we have this Act on Specified Commercial Transactions, for example, which says that in the cases of door-to-door sales, so let's start with door-to-door sales. the business operator cannot say, yes, we orally agreed, so we have a contract. He must give you a document. Why? Yes, Matthew? Microphone?
Just a shot in the dark, but I'd say maybe lack of premises, and so therefore it's difficult to trace them.
Yes, that's one of the reasons. So they also need to mention where their offices are, etc., their contact details. A more basic reason, yes, Chloe, would you like to try? I'm happy that I can identify you today because I won't be able to do it next week. Okay.
I think there are also cases.
I think there are also cases that the consumers want to change the contract or to cancel a product, for example.
Excellent. Why?
And if there's a written document, then they can decide whether the cancellation is valid or not based on the date.
Okay, so what's the characteristic of door-to-door sales, for example? I need you to give me that part.
If it's door to door, when the product is already on its way for delivery, then it cannot be cancelled.
You're very close, but who would like to try? So the question is not well done, but yes. So the question is, as you saw, business operators do not bear the obligation to give us consumers documents in all contracts. It's for door-to-door sales, door-to-door purchases. Okay, let's stay in door-to-door transactions. What is different in cases of door-to-door transactions compared to transactions where I go to the store ready to buy something? Yes, Matthew, would you pass the microphone?
Not sure, but is it because it's the business side that's initiating processes?
Excellent, which means that the
Well,
consumers,
the consumers haven't been given, don't have all the knowledge. They haven't made the choice themselves. They are being perhaps pressured or duress.
excellent, thank you very much. So, in the field of legal studies, we call this the element of surprise. In Japanese, nukiuchi se, which means that you're not ready to buy a thing. When I go to the store, usually I want to look for something, maybe compare something. I have a transaction in my mind. Maybe I'm gonna buy it later, but I'm thinking of buying something, etc. How about when we are at home, Saturday? I'm watching a DVD, Avengers. I'm half naked. And he or she comes and presses the button, and I'm like, oh my god. So I go there and he's like, oh, I'm selling these soaps. And I'm like, oh, what's that? Oh. And you're surprised. There's the element of surprise. And sometimes you want to get rid of them. So you're like, okay, I don't need this, but I'm gonna buy it. Or maybe, as Matthew said, there's a lot of pressure, etc. So we have the so-called element of surprise. In Japanese, nukiuchi. That's why the law obliges them to give you a document. Why is that? Because you can reconsider the content. You can read it, and maybe you will realize that, oops, this is not so good for me. And now we go to what Chloe said. Yes, if you read the document, then you can use your right for cooling off, which is provided again in the Act on Specified Commercial Transactions for the same transactions. So, both Chloe and Matthew are correct. Matthew gave us the first part, element of surprise, necessity to reconsider the content, and Chloe gave us the second part, which is, I have reconsidered and I want to use my right for cooling off. What's that? It's a withdrawal or cancellation of the contract. And under the Act on specified commercial transactions, if the business operator does not give you a document, you have that right forever. So that's a good reason for him or her to give you the document. You can check that on this slide. So, the right to cooling off. Maybe you can easily guess that cooling off comes from I need to cool my head. Okay, I was surprised, I was half naked, etc. But now I'm on my desk, I'm wearing my clothes, I have my legal books, so I can relax, cool down, and maybe reconsider. It's a right to withdraw or cancel a contract within a certain period of time. Usually it's 8 or 20 days, depending on the transaction. For example, for door-to-door sales, it's 8 days. And as I told you, if the business operator does not give you the document, you have that right forever. And this is a very strong right because you don't need to give him a specific reason. You just say, I changed my mind. And you can give the thing back and receive your money back. I would like you to remember this part. There is no cooling off in Japan for mail order sales. Please be careful. This is also interesting for your final exams. What's mail order sales? In Japanese, tsushin hanbai. Mail order sales are the cases where you look at an advertisement and you call the company to buy the product, or you watch an advertisement on the internet and you apply for the product to be bought by you. Was that clear? So you see an advertisement on a newspaper, on a magazine, on TV, on internet, and you contact them and you tell them I would like to buy it. Question for you. So, why did the legislator decide not to give us the right to cooling off in the case of mail order sales? What's different between door-to-door sales, for example, and mail order sales? Okay, let's go to Lily. So, what's your answer?
I think because like for door to door, like the one who's selling the product is coming to you, as opposed to like this one, the mail order sales, like you're the one who's going to, like you're applying for them, like you're the one going to buy it. So like you already have the time to cool off before you like call them or like apply for them.
Excellent. That was perfect. Yes. So that's the reason why. Because nobody. Okay, there are also some exceptions. I was watching TV the other day, and there was that guy, I'm not going to mention the name of the company, who was like, this offer is only valid for 30 minutes. Only for 30 minutes, so maybe there is a bit of pressure on you in those cases. But anyway. But yes, in principle, you have the time to rethink. You can open your books, you can compare with other products, etc., and then you can apply. So you don't have the element of surprise. Okay? But please also remember that there is a goods return system in Japanese Henpin Seido for mail order sales. I'm not going to give you details today. Now, there are some exceptions regarding cooling off. Of course, you cannot give a thing back if you have opened it and tried it. That's quite understandable, etc. And the effects are that you can send the thing back without paying the mail expenses. So, all expenses for returning the thing are borne by the business operator. he cannot tell you, okay, you have exercised your right to cooling off, so send me the thing, you bear the expenses. No. The expenses, according to law, are to be borne by the business operator. Any questions up to this point? Yes, ma'am? Could you please pass the microphone to her?
Thank you. So there are like the goods return system for mail order sales, and what about like the door to door? If like that contract have written that like no return policy or something, and they have you sign for that, like okay, I understand like the terms and conditions, and can we still like rescind the contract? Thank you.
That's an excellent question. So, the provisions about cooling off are so-called mandatory provisions. Maybe you remember we have talked about mandatory provisions. In Japanese, kyoko kite, which means that you cannot change them. You cannot agree something different from them. Which means that even if the business operator gives you the contract paper and it says, we are really sorry, but you have no cooling off rights regarding this specific contract, this does not apply. You still have this right. However, it's limited to usually 8 days. Okay, so you need to be careful regarding that. And your question was really nice because this is different in the case of the goods return system. Why? In this case, the law says that we have, for mail order sales, the right to return the thing for, I think it's 2 weeks. But only if there is no other agreement between us and the business operator. Which means that when you buy something through advertisements on the internet, newspapers, magazines, and TV, you need to look. If it says no goods will be received, so there is no goods return system, that applies. So you need to be careful in that case. Okay? Because this provision on the goods return system is not mandatory. So you can change it by an agreement between you and the business. Plus, in this case, the expenses are to be borne by you. That's why this is not a cooling off system. Okay? So this is also a difference between those systems. Yes, you have a question. Yes, could you pass the microphone to him, please? So yes, Jianming?
The contract. Okay, the contract is not valid, right? But are they allowed to write it to deceive? No, like say the salesman, the door-to-door salesman, write it. It will not be valid, but he read it anyway, and then the person maybe is not very understanding. He read that he thought that it's valid even though it is not. Is it okay for them to write that in the contract?
Okay, so yes, usually I also talk about those issues too. Today I didn't because we don't have so much time, but yes, there is also a provision. Okay, so if the business operator tries to prevent you from using your cooling off right, then again, the cooling off right does not expire during that period. So, for example, if he lies to you, if he tells you, this door-to-door sales we are doing today, it's an exception. You don't have a cooling off right, which is wrong in that case. And you think that you don't have a cooling off right, and you miss the 8 days. Of course, if you manage to prove that, then you can still exercise that right, because the period does not lapse. If he or she has wrongly induced you the idea that you don't have the right. So, let's move to our next topic, which is I found an old picture of mine again, a photo. And each time I find a photo of mine, I would like to share it with you. So, this time it will be quite difficult for you to find me. Did you find me here? So, this was in Greece in 2003. Mr. Abe and Mr. Koizumi was then Prime Minister. Did you find me? Yeah, Yes, exactly. When I showed this photo to my parents, they were like, "Where's your jacket?" It was, it was really hot and I'm Greek, so yes, it is not so Japanese. You shouldn't forget that I'm Greek. Okay? I'm half Japanese, half Greek. Anyway, so yes, you can see that even after globalization, nations are different. Okay? You can use this photo as a proof if you want. For example. So, let's move to the Consumer Contracts Act. I need you to be careful. I need you to try to compare today's content with last week's content. So, we are going to talk about some provisions in the Consumer Contract Act which protect us better compared to the Civil Code. You need to remember that you can use the Consumer Contract Act only if there is a consumer contract, which means a contract between a consumer and a business operator, which means that you cannot use it for contracts, for example, between individuals. Now, rescission of manifestation of intention. What's that? It has to do with the first part of the contracts. So last week, if you remember, we were saying that we have two phases. The conclusion phase, where you negotiate whether you will conclude or not the contract, and the phase after conclusion, where you talk about the content. This has to do with the conclusion phase, the phase where you are negotiating. We have two notions: mistaken belief, gonin, and distress, konwaku. What's the difference with the notions in the Civil Code? Mistaken belief is something like fraud, which is not fraud because it does not fulfill all the requirements for fraud. Distress is something like coercion, duress, but it's not duress because it does not fulfill all the requirements. But you can still rescind. Let's have a look at the concrete content. Please be careful. All this part is really important for your final exams too. We will start with number 1, mistaken belief, gonin. So, you need to keep in mind the development. Before the CCA, the Consumer Contract Act, we only had the Civil Code. So if somebody told you a lie to sell you something, you could use the provision on fraud. You needed to prove double intention. Now, in the CCA, so please have a look at Article 4. Yes, Article 4 is really long. I'm not going to ask you to read it all because it starts from page 2 and it ends on page 4. However, please have a look at Article 4, paragraph 1, number 1. Who would like to read this part? Yes, please. What's your name? Oh, could you pass the mic?
My name is Enzo Constantin.
Okay, thank you.
So page 2, right?
Yes, so Enzo, it's the first time you raised your hand.
Yeah,
Thank you, thank you. May I ask where you come from?
from France.
France, okay, that's so nice. You have the code de la consommation. I'm really
Yeah, we
happy. Okay, so it doesn't have to be with the others, it's just between us. Okay. So, Enzo, could you please read Article 4, Paragraph 1, only number 1, so the part which says number 1.
A consumer may rescind this one
Uh,
or misrepresentation.
Okay, so yes, if you could, it would be better if you could start from the part you said and then go to number 1.
Okay, rescission of the manifestation of an intention to offer or accept a consumer contract. Article 4.1. A consumer may rescind the manifestation of his/her intention to offer or accept a consumer contract if either of the actions listed in the following 8 items, in which the business operator engaged when soliciting the consumer to enter into such a consumer contract caused by the consumer to be under the mistaken belief listed in the relevant item, based on which the consumer manifested the intention to offer or accept the relevant consumer contract. 1. Misrepresentation as to an important matter. Mistaken belief that said misrepresentation is true. Or,
Thank you. So that's number 1. It says misrepresentation, in Japanese, fujitsu kokuchi. It's the case where the business operator creates in you a mistaken belief that the content of what he said is true. So, I will give you some examples, which you cannot find in your slides, but you can take some notes, of course. And as you remember, this lecture is called Law and Culture in Japan. So we also need to refer to the Japanese culture. So, Japanese culture number 1. Yes, pachinko. Actually, I've never been to a pachinko, so I cannot explain you how it actually works. I think that you pay some money and you receive these balls, and then you press some buttons and the balls flip. Who would like to continue in English? Yes, so could you, I haven't played bingo, so could you, yes, so could you please pass the microphone to Matthew? Don't worry, even if you explain this, it doesn't work as a presumption that you have been in a pachinko, okay? Maybe you have read it somewhere. So, yes?
Maybe it's like vertical pinball.
Okay, which means?
Well, pinball is this type of old arcade game where the ball would come in and you had two little bats at the bottom and you could push the ball up and get scores by what it bounced off of.
Okay, thank you. So, yes, so I think that description is quite but I think it's a bit more complicated. It also has to do with AKB and some other animations. And you also have numbers, which is, yes, I'm not sure. Yes. So why are we talking about pachinko regarding the CCA? Because misrepresentation, the typical first cases which were disputed in front of Japanese courts were cases of pachinko. I think the English translation is also pinball game for pachinko too, I'm not sure. Where there were companies selling books with hints and tips on how to win the pachinko. Now, I know it sounds a bit funny because an ordinary person would think, yes, so if you know how to win, why don't you go yourself and win a lot of money? Why are you selling me that information? But, okay, some people don't think about that. So they bought this book, which costed 150,000 yen. And it's not only one person. You can see there were many persons anyway. So, of course, it did not work. They went to the store, they did what this book was saying, the manual, but they didn't win. So, They were quite lucky because it was after the CCA, the Consumer Contract Act, was established. So they said, oh, maybe we can use Article 4, Paragraph 1, Number 1. Why is that? Because if you read again Number 1, it does not say that this needs to be done intentionally in Japanese coin. Which means that even if the business operator tells to the court, I was so sure that this information will work, the court will say, oh, we don't care about that. What we care is whether what you said is a lie or not. So you can see the difference with fraud. In the case of fraud, it's not whether it's true or false. It also has to do with the intention of the business operator. In this case, no. So, the center of this dispute was, is this information true or not? So it's a bit like a Hollywood movie. You're having a pachinko expert coming to the court testifying. As an expert on pachinko, I can testify that this information mathematically is not correct. So you cannot win even if you use it. And the court said, oh, yes, now we have proof that this information is, Number 1, a misrepresentation. So you can rescind the contract, take your money back, and of course give the money back. 5 minutes break. If you have any questions, feel free to ask. But that's also yes, yes, yes. Thank you. I will give you the answer in the lecture because there's something which I will explain on another Does it say also is it mentioned sorry? Yes, and it's defined in the information. So let's continue. So the first was misrepresentation. Yes. I forgot to tell you. So it's quite easy to remember this content. If you think about a not so good boyfriend or not so good girlfriend, what does a not so good boyfriend or girlfriend does is 1. Lies. 2. Says that everything is gonna be fine although he cannot be so sure. And 3. Mentions only the good issues and does not mention the bad issues. So if you think of a bad boyfriend or girlfriend, you can easily remember these 3 cases, okay? Telling lies, being 100% sure on something which cannot be so sure, and number 3, telling only the good things and omitting the bad things. So, let's go to number 2. Provision of conclusive evaluations in Japanese 断定的判断の提供. This is what I just told you. So, who would like to read number 2, paragraph 4, article 4, yes, Yuki? Paragraph 1, number 2. It's on page 3. Yes.
Providing conclusive evaluation of future prices, amounts of money that a consumer should receive in the future, and other uncertain items subject to future change with respect to goods, rights, services, and other matters that are to be the subject of a consumer contract. Mistaken belief that the content of said conclusive evaluation is certain.
Thank you. So, I will give you a typical example. I have not prepared a slide on this because it's quite easy. In Japan, what happened was again on pachinko. So there were some advertisements saying 100% you will win if you use this manual. And people were calling the company to buy the manual, and they were told that yes, it's 100%. So please be careful. There is a difference between number 2 and number 1. In case of number 1, you just need to tell a lie. So if the business operator is telling something which is not true, it's a misrepresentation. In case of number 2, as Yuki read, we need to have something about which you cannot be so sure, but you provide conclusive evaluations. So this does not have to do only with Japan. That's why I have not prepared a slide. It has to do with other countries too. Stocks, kabu, stocks. If you buy this stock, it's gonna be expensive in the future, 100%. I'm really sure. It happens in many countries. So in Japan, it would be number 2, provision of conclusive evaluations. Number 3, omission of disadvantageous facts. In Japanese, 不利益事実の不告知. This is Article 4, Paragraph 2. Who would like to read this paragraph? Yes, Yuki? There are 2 Yukis, okay? Yuki number 1, Yuki number 2. I don't know who is 1 and who is 2, but okay. Yes.
A consumer may decide not the manifestation or his or her intention to offer or accept a consumer contract with a business operator when soliciting said consumer to enter into said contract. This represents only the advantages of an important matter or a matter related thereto, but intentionally omit disadvantageous facts limited to facts that a consumer would normally consider to be non-existent by such omission about such important matter, causing said consumer to mistakenly believe the non-existence of such facts. However, this shall not apply where said business operator has attempted to communicate such facts to said consumer and said consumer refused to hear such attempted communications.
Thank you very much. Please underline intentionally. Please underline intentionally. Please underline intentionally. Why am I saying this 3 times? Because somebody asked me, do we also have to remember the provisions? I was like, not the ones which are not important, but the ones I have emphasized during the lecture, yes. So, in order to emphasize something, you need to say 3 times, according to my professor. Yes, I had a professor in Greece who was saying, the first time you say it, the students will think he's saying something. The second times, they will be, okay, let's try to realize what he's saying. And the third time, they listen to you. So he was like, you need to tell important things 3 times during the lecture. Please underline intentionally in paragraph 2. Why? This is different from numbers 1 and 2. As you remember, I told you that in number 1, we don't need to have intention. In number 2, the provision which Yuki read, it also does not say anything about intention. So, number 2, even if the business operator really believes that this stock is going to be more expensive in the future, he's 100% sure. That's why he told you, I'm 100% sure. We don't care. It's a conclusive evaluation about stocks, and nobody knows what will happen with stocks, so you can rescind and receive your money back. In case of number 3, there needs to be intention regarding what? The omission. It says intentionally omits disadvantageous facts. Example. In Tokyo and in Fukuoka, there were 2 lawsuits regarding an apartment, a purchase of an apartment. You go with your future husband or your future wife in a high apartment, in a very tall apartment, and for example, your girlfriend tells you, you know, darling, if you buy the upper floor, maybe I'm gonna marry you. So you're like, oh, okay, so let's gonna have a look. You go there and it's really beautiful. But there is a plan according to which, after some months, another tall building will be built on that side, so there will be no view. Now, both in Tokyo and Fukuoka, the same thing happened. The person who was selling the apartment knew about the planned future construction, but he did not mention about it. So it's of course intentional, because he knew. He only emphasized the really nice view, and he omitted to tell them about the construction plan. They rescinded, and they received their money back. This is so helpful. Now, a student asked me before, Ken, you asked me about number 1, misrepresentation. So what happens if on the pachinko manual or on the advertisement, it says, you know, the information we are providing you, maybe it's not so correct. There are cases where it's not so correct. Answer, it depends on the case. Let me explain you about case number 3. In this case, what happened was that on the pamphlet about that apartment, it said the view, in small letters, the view might change in the future. So the business operator said, look, it says the view might change in the future. What was the court's decision? No. You need to concretely mention when and how, if you know. So it's not enough to say that, you know, in the future maybe, because that means that maybe the view will not change. It has 2 meanings inside. So, according to the court, you need to be specific. So, my opinion, it's not enough if you say, you know, the information might be a bit wrong. You need to be specific, okay? Just mentioning in general that might something usually is not accepted by the courts. It was a very good question. Thank you, Ken. Any other questions regarding this part? Yes, Calvin, the microphone, please.
Okay, so it's the business operator, the whole business. So it's if the employer omit the fact from to the employee, and the employee unintentionally do not give the fact to the consumer, is the business liable?
That's a good question. So, if you have a look at the provision, it's a contract at the provisions in general. It's a contract between a consumer and a business operator. So it's not a contract between you and the salesperson, it's a contract between you and the company, so you're correct. Even if the salesperson didn't know, if the company knew, then it's intentionally not giving that information. Okay, it's a very good question. Any other questions? So, to summarize, how do you memorize this? Bad boyfriend, bad girlfriend. Okay? Lying. Things are gonna be 100% sure, my honey. Number 2. Number 3, omitting the disadvantageous facts. So, let's move to distress. What's that? Again, as you remember, in the Consumer Contract Act, we have 2 categories. We have talked about mistaken belief, number 1, which has 3 subcategories. Now we will move to number 2, distress. Here we have 2 categories, failure to leave and preventing a consumer from leaving. Again, we are still at the conclusion phase, negotiating, etc. Who would like to read Article 4, Paragraph 3, numbers 1 and 2? Yes, please, Lily. Oh, sorry, Lily. So could you split? So Lily, you will read up to number 1. And was it Eriko? Yes, Eriko will read number 2. Okay? She's just behind you.
Failure to leave a consumer's residence or place of business in defiance of the consumer's.
Okay, could you please start from paragraph 3? Yes, maybe
okay.
Thank you.
A consumer may resign the manifestation of his or her intention to offer or accept a consumer contract if he or she is distressed as a result of either of the following acts engaged in by a business operator when soliciting said consumer to enter into said consumer contract. Failure to leave a consumer's residence or place of business in defiance of the consumer's request that the business operator leave such place or
preventing a consumer from leaving a place where the business operator is soliciting the consumer to enter into a consumer contract in defiance of the consumer's request to leave.
Thank you. So here you can see that it doesn't have to do with telling lies or omitting information, etc. It has to do with creating distress, konwaku of the other person, by failing to leave or preventing a consumer from leaving. Yes, so I know that, I guess that you want me to connect this again to relationships. This would not be a bad boyfriend or a bad girlfriend. It would be a person with whom you are still friends, but wants to become your boyfriend or girlfriend. So he or she tells you, I'm not leaving today. Or he or she tells you, you're not going to leave today. It's the same, okay? So it's quite easy for you to remember it that way. Now, as you can easily understand, I showed you this slide last week. In the 1950s in Japan, Oshiuri, aggressive or high pressure selling. I showed you this too. Now, as I told you, people evolve. For example, I cannot be Karaiskos forever. I need to become Karaiskos 7 one day, Karaiskos 7S maybe in the future, like the iPhone. We all need to evolve. So, these people also evolve. Nowadays, they will not tell you something bad will happen to you, etc. because it's also a breach of some penal code provisions. So it has to do with imprisonment, etc. They're a bit more nice. So, what happens? A case in Tokyo, 2007, the salesperson visited him and tried to sell him desiccant mats, in Japanese, joshitsu matto. Now, he was really nice. He was using really nice language. It's a door-to-door sales. So X was maybe half naked, etc., sleeping, watching Avengers, etc. And the salesperson told him, would you like to buy these mats? He said, I already have enough of them. So the salesperson told him, okay, let me explain you once more about the mats. So he said, I don't want discounts, I don't want to draw any money, I don't want any. So the salesperson told him, okay, let me explain you about these mats. He said, I have enough, I can't buy any more, etc. So he said, okay, so let me explain you once more about my mats. And this continued for 1 hour. And he bought the mats. He went to court and he rescinded the contract and received his money back. Now, please be careful. Before the CCA, before the Consumer Contract Act, this would not be duress. Why? Because he's not telling him, if you don't buy this mask, then I'm gonna do something to you, etc. He's just not leaving. But you can easily understand that this is causing distress on the other person. It's the same as with your future boyfriend or girlfriend saying, I'm not leaving, okay? So, you can understand that this is very helpful for us because you don't even need to say, go away. According to the Japanese courts, if you say, I don't want, I'm not buying, I'm not interested, it includes the manifestation of intention, go away. It's the same. Okay? So, this has to do with Japanese culture too, because maybe abroad, in Greece, nobody would have a problem. They would be like, okay, see you again, bon. That would be the end. But in Japan, people are maybe more polite. So they would say, I'm not so interested. It looks nice, but maybe not. But maybe I'm a bit busy. And I've become quite Japanese too. Usually I use the busy word, isomashi. Okay, when I receive door-to-door sales, I'm like, oh, I'm sorry, I'm so isomashi now. But then I become Greek, I'm like, so it's the same. but the first part of me is also a bit Japanese now. So, according to the Japanese courts, you don't need to say to him, leave my house or go away. Okay? This is really important. How about case 2, preventing a consumer from leaving? This also happens a lot in Japan. I was once in Fukuoka, which is my mother's hometown, and there were people distributing pieces of paper on which was written, if you come to our futon presentation gathering, futon are the, how do you call them in English? Wedding, okay. To this gathering, then you will receive some Robano mini breads, which are quite delicious Japanese breads. So my mother went because she likes bread. They closed all the doors. They had some big guy standing in front of the doors, and they started explaining about the futon. Nobody was interested. They wanted just to take the piece of bread. And that continued for 2 hours, I think. So you can easily understand, realize that it's not so easy for you to stand up and say, just give me my bread, I want to go back home, okay? So this is also a situation where you could use this article. Of course, if you bought the futon because of that situation. So this is quite useful too. Any questions here? And let's move to the last part of today's lecture. The regulation of content. We have 3 provisions. I'm not going to ask you to read the provisions. Why is that? If you have a look at today's provisions, Article 8, 9, and 10, they start from page 4. they continue on page 5 and page 6. But I would like somebody to read this slide. Just this slide. Okay, I'm not sure who was faster. So, Chloe, you read 1 and 2, and Lily, you read 3. Okay. Or would you like to read 1 and 2 and she reads 3? No problem with me too, so. Okay.
Regulation of content. 1. Nullity of clauses which exempt a business operator from liability for damages. 2. Nullity of clauses that stipulate the amount of damages to be paid by consumers. 3. Nullity of clauses that impair the interests of consumers unilaterally.
Thank you. So, if you have a look at Article 8, the title is, as Chloe read, Nullity of clauses which exempt a business operator from liability for damages. We are not going to talk about this provision. If you read it, it's important for you. It has to do with cases where you go to a gym, for example, an athletic club, sports club, and it says, we bear no liability whatever happens to you. Is that effective or not? If you read the provision, you can make a decision, a judgment on that. Number 2, this is important. Nullity of clauses that stipulate the amount of damages to be paid by consumers. For example, many of you remember this. It's the day where the results of your entrance exams to Kyoto University, for example, were announced. This is not a photo from Kyoto University, I'm sorry. So for international students in Japan, this is the way, the basic way of announcement of the results of entrance exams for public universities at least. You need to check whether your number is there, etc., and you can take a photo like that guy is doing there, etc. So, what does this have to do with this provision? This provision says, nullity of clauses that stipulate the amount of damages to be paid by consumers. For example, in Japan, before the CCA, most universities were saying, after we make, so it has to do with private universities, because in Japan, first you announce the results of private universities' entrance exams, and then you announce the results in general of public universities' entrance exams. So in Japan, you have the so-called suberidome, which is difficult to explain in English. So you choose a private university which you're sure that you're going to pass the bar exam, the entrance exams, and if you fail the public university exams, then you go there, or at least you can have the position of a student there, even if you don't actually go. Now, what's the issue? In the past, most private universities had a provision in their contracts with you, future students, which were saying, we announce the results, you pay the entrance fees and the tuition fees, and we don't give you back what you have paid, even if you don't come to us. Which is quite a lot of money, yes. Sorry? No, sometimes it's the whole amount. So you pay the whole amount, entrance fees plus the tuition fees for the first year or for the first semester. It depends, I think, on the university. And most private universities were saying, we are not giving you back what you have paid, even if you don't come to us. Which was a good business for private universities. After the CCA was established, many lawsuits occurred because people realized that maybe we can use number 2. So, please have a look at Article 9. I would like somebody to read Article 9, number 1. So the first part, okay, Saki, please.
The following consumer contract clauses are void to the extent provided in each respective item. 1. Clause that stipulates an amount of liquidated damages and/or establishes a fixed penalty in the event of cancellation, wherein the total amount of damages and/or penalty exceed the normal amount of damages that would be caused to a business operator by the cancellation of contract of the same type in accordance with the reason for the cancellation, the time of the cancellation, etc.
Thank you. So, people file lawsuits saying that this provision, this clause in our contract, which says that the university keeps the whole amount, exceeds the average amount, the normal amount of damages that would be caused to the university. Now, let me only give you the result. It went to the Supreme Court. The Supreme Court said that entrance fees, in principle, you don't have the right to receive them back. Why is that? According to the Supreme Court, entrance fees in Japanese Nyugakukin is the money you pay to achieve the status of a student in that private university, which means that even if you don't go there, you have acquired the status of a student of that private university, so that money goes to the university. Regarding tuition fees, Jugyoryo, the Supreme Court said it depends on when. If it's on March 31st or before, then there is no damage created to the university because the new year, the new academic year has not started yet. So, in principle, you can receive your money back. If it's on April 1st or after, then you cannot, in principle. Second issue, key money, deposit, and renewal fees. If you're living alone in apartments in Japan, maybe you have paid one of these or all of them. I will also continue next week, but let me give you an idea what happens. Key money in Japanese reikin is a present. So when you rent an apartment, sometimes the contract says that you pay this amount, which is not returned to you. It's a present. Does anyone know how this started in Japan? Because Matthew. Okay, so yes.
It started in the post-war era where there was a lack of housing, a genuine housing crisis, so there was competition to enter rental accommodation. Therefore, the best way was a form, essentially, bribe.
Excellent, thank you very much. So you can see that the situation has changed, which means that this has no meaning nowadays. So additionally to what Matthew said, there were also situations where young people from the province were going to Tokyo or Osaka to study, and their parents would give them a small amount of money to give to the landlord, etc., in order to take care of them if something happens. So that was the original, the initial meaning of this amount of money. Nowadays, it has no meaning. In Greece, if you decide to rent an apartment, maybe they would give you a present. They would be like, thank you for coming to us and not going to another apartment. It's the other way around, but anyway. So, according to the Supreme Court, unfortunately, there is no Supreme Court decision regarding key money. But deposits and renewal fees, what are these? Who could explain this? Yes, Matthew?
A deposit works as essentially a form of insurance. Therefore, for example, if you break a light fitting, the money will be taken out of the deposit to fix it. However, at the end of your tenancy, you can receive a percentage of the deposit. So even if you break nothing, you will not receive all. Renewal fee is usually every 2 years in most contracts. You have to pay, I think it's on average about 3 months rent and to renew your lease, essentially.
Excellent. What did the Supreme Court say about these two? Legal, even under these provisions of the Consumer Contract Act. we're gonna start from this issue. I'm gonna give you more details next week. If you have any questions, feel free to ask me. So see you next week. One small issue. Sorry. We'll finish in 1 minute. Sorry. Just let me give you one small information and we finish. So, congratulations. Why is that? Well, because we have finished with law in everyday life. Yay! So, from next week, lecture 10, we will start with social issues and the law. We will deal with concrete disputes, so the content of the lecture will slightly change. Okay? So, see you next week.